Let's get started. Okay, so today we're going to give you a skeletal view of the basics of the foreclosure process. Has anybody that's in attendance, has anybody bid or been successful at buying foreclosures from the clerk? The necessity for foreclosure. A foreclosure is a legal process in which a lender seeks to recover security for a loan made to the property owners. At the time of the property's purchase, the buyers execute a note and a mortgage. The foreclosure is the legal remedy that seeks to repay the lender for the money given to the buyer. So I just said a mouthful. I'm going to break it down for you. When you close on your house, you buy a note and a mortgage. The mortgage is the evidence of the debt, and the note is the promise to pay. The note is held by the lender. The mortgage is recorded in public records. Bankruptcy, as I spoke to Rick about this yesterday, bankruptcy is not going to do anything but stall a foreclosure action, because the bank's attorneys, they've been through this a lot. And what they'll first do is they'll ask the bankruptcy court for relief from the bankruptcy stay. And a stay is when you're not allowed to move forward in any fashion or way, especially in a way that's going to be detrimental to the party that filed bankruptcy. So if a defendant files bankruptcy, it's only going to stall the foreclosure, sometimes for 30, sometimes for 60, but generally not more than 60 days. Because the bankruptcy court is going to seek to extinguish the power of the note for the lender to get a deficiency. Other than that, the security for the debt is the mortgage. The lender will be entitled to foreclose and continue in the foreclosure action, even though the borrower has filed bankruptcy. I know this isn't a bankruptcy seminar, but that just bled right into it. So I'm sorry about that. Okay, so what does this say here? Hold on. Okay, state law. Florida is a judicial state. You do have a lot of states. There are also non-judicial states. Judicial states are they take more time with foreclosures for judicial states. They take less time for foreclosures than non-judicial states. And the difference is, in a judicial state, there's a judge, there's attorneys on both sides. All parties have attorneys. In a non-judicial state, the plaintiff's attorney runs the whole boat. They're the guys that take care of everything. They advertise the sale. They hire the auctioneer. They pay the auctioneer. They run the stuff. Personally, I like judicial, partially because I was raised and brought up in it in Florida, and also because I like having an authority there, somebody to go there to settle arguments or disputes. Title or lien theory state. We are a lien theory state in Florida. So the mortgage that you sign at your closing is recorded as a lien in the public records. In a title theory state, the bank holds the ownership of the property in their hands. So they hold title, and they'll only give it back to you when the mortgage is paid off, but they'll keep it. And they don't, it's not done in a mischievous way. I mean, that's just the way the state law is, but it's different than what we're used to in Florida. And when you travel or venture into a non-judicial state, it's going to feel foreign for anybody that learned foreclosures judicially or in lien theory. And that's what we are in Florida. So that's pretty much what I focus on, because that's all I know. Let's go to the next one. Okay. The foreclosure process in Florida. This is the way it works. The borrower defaults. So the borrower defaults. Now, the one thing that I found that I'll go to note conferences, and a buyer of a note wants to foreclose 15 seconds after he takes possession of the note. Can't do that. There is a default letter process that has to take place, where the borrower has to have a chance to understand what's happening to them, and they have to have a chance to cure the default. So instead of immediately foreclosing because you now own the note, once the borrower defaults, the attorney for the plaintiff sends out a letter, and the borrower, I believe, has 20 days to reply. Now, because most borrowers don't reply to a default letter, the attorney for the plaintiff has probably already started putting his foreclosure package together. So number 2 is the notice of default that the attorney sends out. The legal action is prepared and filed by the lender's attorney. The borrower defaults, the notice of default, and the legal action being prepared, that's all pretty much, within a 30 to 45 day period. Because once the bank decides it's time to foreclose, they're going to move forward with it pretty quickly. Because you'll probably understand, or you see this, that some banks will wait 3 months of default before they start foreclosing. Others will wait 6. Others, there's outside mitigating complications to the foreclosure that they didn't choose to foreclose until maybe 9 months. But the fact is, there's no law that says how long the lender can wait to foreclose. As a matter of fact, they can foreclose on you after your late 30 days, as long as they follow these steps: notice of default, and then everything get put together. The clerk of the court will then record an LP that's prepared by the plaintiff's attorney. It's an LP prepared by the plaintiff's attorney, as you see, lis pendens. And that's what foreclosure investors that like to deal with the foreclosure defendants before the sale, that's your marker. That's what you look for, is the LP. You want to find that LP in the public records. That lets you know, that's the first public notice that there is a foreclosure sale pending regarding that property. And that puts the world on notice, so that somebody that loans these guys money after the LP is filed can't say, I didn't know. Because anybody that loans money and records a mortgage after the LP will not have their day in court. They won't get named, they won't get served, but they'll get foreclosed out, because the LP is the record that says, don't do anything with this property because there's a lis pendens. Figure out what's going on before you get involved. So that's why the LP is in public records. Then after the LP is filed, once the attorney sends his package in, part of the package will be all the parties will have to receive a summons and a copy of the complaint. And they'll have 20 days to reply to that. Now, as you probably are aware, when a mortgagee, or when you buy a house, the mortgage makes sure that they are the number one priority lien on that property. First in time, first in right. So the first thing you'll do is, at a closing, is you'll execute the deed first. Then once you own the property, you can then execute a mortgage to put a lien on that property, because you can't do it the other way around. Now, I'm sure that there's some people that are some closings that the documents are executed in reverse order, but they have to be recorded in the proper order. In other words, you can't put a lien on something you don't own. So if a property gets sold to Rick and the mortgage gets recorded before the deed, that mortgage is invalid. Now, can a lawyer make an argument? I think so. I think they could say it was just a mistake, but if it goes too long, the lender is not going to be happy, and it's not going to be a loan that they can market. So that's a good deal for a buyer, a mortgage buyer. But I'm getting offhand here. So what happens is, Rick buys the house, signs a deed, signs a mortgage, and then it goes into default. The attorney sends the letter. The action is prepared by the attorney. The LP is filed with the clerk, and the clerk records it, and everybody gets a 20-day summons. They have 20 days to file an answer. When I say everybody that has any interest in that property are the people that get served with a summons. So if you have a credit card judgment, if you have a second mortgage, if you have a lien from your pool guy, they're all going to get served with this notice. And even though they're gonna get eventually defaulted out, that's a story for another day. We're not going to get into that. But we're going to talk about the foreclosure process. Answers and defaults in orange. What happens is, everybody gets 20 days to file an answer. If they choose to file an answer, we'll go to the gray square. If they don't file an answer, they get defaulted out. Now, what happens when you get defaulted out of a foreclosure action? When you get defaulted out of a foreclosure action, what happens is you stop being able to receive documents from the foreclosure action. You won't receive them in the mail anymore. At least that's the way it used to be. So if you file an answer, we'll go to the gray. If you don't file an answer, you get defaulted out, and you just don't get copies of pleadings anymore. If you file an answer, over here to the gray one, attorney overcomes every answer. What has to happen is, the attorney will have to set hearings for every answer. A lot of times he'll do it on motion calendar, which is something that goes quick, and he can set 3 or 4 answers at the same hearing, and he'll just explain to the judge why this party doesn't have superiority to his client, because he's the first mortgage, and they'll just dispose of the answer. So the filing of an answer by a junior lien holder or by any other defendant other than the property owner is pretty much going to be set aside really quickly by the judge. No, I can't read that yellow one. Okay, motion for final judgment. So what happens is, once all of the answers are disposed of in the court, and dispose is kind of a harsh word, they're dealt with by the judge, and they're deemed not to have any merit with regard to their superiority versus the mortgage. The mortgage is first in time, first in right. He's the first guy recorded. Everybody else's lien is going to be subsequent to that mortgage. Remember, we talked about that. Right after the deed, the mortgage appears. Now, the only other person that I didn't talk about yet was the defendant. So if the defendant, the homeowner, if they file an answer, I don't believe that the court allows a defendant answer to be dealt with on motion calendar. And I could be wrong about motion calendar. It could be all hearings might have to be special set. And that's part of the foreclosure process in Florida that drags on. Because if every answer has to be special set, or even if a group of answers have to be special set, the time that the judge has available for special set hearings is based on his calendar and how busy his docket is. So the attorney for the plaintiff may have some trouble. In other words, he may have to wait 30 days or 45 days to get a hearing to overcome that answer. Now, if it's the defendant filing an answer, the homeowner, if they file an answer that has any merit at all, it's going to have to be special set, and the attorney's going to have to prepare for it. Now, let me give you an example of an answer that has no merit. If you get served with a foreclosure action, you could file an answer that says simply this: I had a ham sandwich with mayonnaise yesterday. And you put answer at the top of the paper and you mail it into the court and you call it an answer. The court will address it and presume it's an answer, although you can tell the ham sandwich story has no merit. If you have an answer that has some merit, I didn't receive this notice from the bank. I made a payment and they didn't credit me. Anything like that has a sliver of merit is going to cause the attorney to have a little bit of anxiety. He's going to have to get ready for the hearing, and that's going to take more time. So, Rick, yesterday we were talking about how we stress that defendants, you want to encourage them to file answers if you're working with them on a short sale or even on a straight up sale. You want to encourage them to file an answer because that delays everything. So that's the heartbeat of what we talked about that yesterday. So let's see, motion for final judgment. Okay, so once all the answers have been addressed by the court, the plaintiff's attorney, they're the one driving this car. The plaintiff's attorney just keeps moving forward. They set down a motion for final judgment. And it's up to the judge at that time to decide whether or not they're going to grant the final judgment. In most cases, when a plaintiff's attorney files a motion for final judgment, it's too late to do anything with the homeowner. So if you're working with a homeowner, Rick or Ray, if you're working with a homeowner and you check the docket sheet and you see that a motion for final judgment is set for next Tuesday, there's not a lot you can do. There's not a lot that a normal lay person can do. Now, when I say lay person, I mean everybody like you and me, somebody that's not a lawyer. Because if you're still intent on trying to help this homeowner, they're going to have an attorney. Because the attorney may be able to go to the final judgment hearing and ask the judge for more time, let him know we're doing a short sale, we're doing some loss mitigation, anything to help keep this homeowner in the house. And most judges will allow something like this to delay a motion for final judgment, maybe once, maybe twice if you're showing progress. But the key is the defendant will have to hire an attorney. You have to find someone that'll work on a tail end deal to where they can make some money when everybody has money. So that's one of the more difficult processes. And if you stay tuned onto my short sale webinar coming up at 11, I discussed the attorney. And when I did last week also, when you pick an attorney for short sales, you in a perfect world, the attorney's used to going to court. He's not just a title guy. He doesn't go to court. He has no experience. He has a ticket to go to court, but he hasn't been there. And the next best thing is somebody that has consumer protection law background, because those guys are like tigers. And if they smell blood, they will not only get into a frenzy, they'll eat somebody. So but it's kind of hard to find a consumer lawyer that has a title company. But listen, maybe they work together, maybe you know somebody, but that's a story for another day as well. So we have the motion for final judgment after all the answers had been dealt with. We have the final judgment entered in favor of the plaintiff. All right. So that essentially speaks for itself. Let's go to the contents of the final judgment. What the final judgment has in the body of it, it has all the money that's owed to the plaintiff. So everything that they asked for, essentially, they're going to get. If they're prejudgment interest, attorney's fees, whatever they wanted, they're going to get, because unless somebody in the group hired an attorney like the defendant, there's nobody to push back. So the judge will take the attorney's word for it, because the attorney is supposed to be honest and forthright and an officer of the court and all that. So the judge is going to pretty much believe whatever the plaintiff's attorney says. So they get a big fat final judgment. It's going to tell you what the sale date is. Sometimes the judge leaves it blank. And in Broward County, for example, the clerk of the court will give them a sale date. So you get the order from the judge signed, the final judgment, you hand walk it down to the clerk, and they'll write in what the sale date's going to be. And then it gets into the docket, and it gets into public records. One of the more important features of the contents of a final judgment when you begin to buy foreclosures is the writ of possession. Some judges require an additional hearing if there's going to be the need for a writ of possession. Other judges will let it go without hearing. So the final judgment, it's true, is drawn up by the plaintiff's attorney. And after you start buying for a while, you'll be able to tell which attorneys look for hearings before the writ of possession can be issued and which attorneys do not. That's just something you have to look for in the final judgment, because if you don't need a hearing to get your writ, right after 10 days is over, you get your CT, and now you can put the people out. You can get in line to get the sheriff to get over there to put them out if that's the way you want to go. But if CT is issued and you have to have a hearing, it costs more money, and it's going to take 2 weeks. So whenever I'm buying a property at the foreclosure sale, I want to see the final judgment, because I have to price everything in. The easier, the more I can pay. The harder it is, the less I can pay, because I don't want to be aggravated. And at my age, if there's something that has a writ of possession that requires a hearing, and the judge has a history of busting people's chops, I'm not going to deal with it. I'm going to buy something else. That's just the way that I am. But you guys still got energy. You'll go ahead and you'll do that. I get a finite amount of energy every day, and it gets used up. Like that walk in the hot sun yesterday, that used everything I had. Okay, foreclosure process. Okay, so the sale date is set and advertised. So the clerk sets the date of the foreclosure sale, and then they publish it in a legal newspaper. Now, it used to be, what was that called? The Broward Business Review or the Miami-Dade Business Review. It's a business newspaper. Essentially, they were created to be able to offer advertising at decent rates to plaintiffs in foreclosure. But those newspapers are long gone. They're long gone. So now, if you look in the Penny Saver or the Jewish Journal or this, or save a nickel off your salad newspaper, it's in all those rag newspapers is where you find advertisements anymore, because they're the only ones that are around, and you have to publish. And I know that now that sales are online now for a bunch of years, they're going to have to come up with another way to advertise the sale, because newspapers just aren't around anymore. And the big newspapers like the Orlando Sentinel and the Fort Lauderdale News Sun Sentinel, their advertising rates are too stupid. So you can't, if you try to get, because it's going to take 6-8 inches in the paper, you can't get that. It's going to cost you $1,000, and that cost to get added on, and it's onto the defendant. So it's just not reasonable, but that's my own opinion. Okay, so now the sale is held. The sale is going to be held. Most counties is going to be online. I did a couple of videos about how to set up your account in Broward County if you want to buy. It's the same for Orange, because it's all on realforeclosure.com. So you go there, you set up an account, doesn't cost you anything, but it gives you access to the calendar and which properties are coming up. Okay, the property is sold to either an investor or the plaintiff. There's one other outcome potentially, and it's a cancellation. The property gets canceled. It can be canceled for many, many reasons. It doesn't matter what the reason is to an investor. We don't care. All I can tell you is that 95% of the properties that get canceled in foreclosures are going to come back. So save your research. If your sale got canceled, you'll just have to update it, and you won't have to recreate the whole package. However, on a side note, if you're buying tax deeds, it's just the other way around. So if 95% of foreclosure, or if a foreclosure is canceled 95% of the time, it comes back, 5% it doesn't. It's just the other way around. Tax deed cancellation, 5% it comes back, 95% it doesn't. So your tax deed sales get canceled. You might as well consider that a death blow. But that's a story again for another day. The issuance of certificate of sale extinguishes the defendant's right of redemption. The defendant's right of redemption used to be a little shorter, and I don't really remember exactly when the right of redemption was expired prior to this, but the legislature in Florida has moved it up to when the certificate of sale is issued. So if you're an investor at the sale, Ray, you buy a house, you know what the rules are. You have to show up by a given o'clock on the same day to make final payment and certified funds to the clerk. When you make those final payment, the certificate of sale is issued to you right then. That is proof positive that you have paid for the foreclosure, because you don't get that document unless you pay for it. So the certificate of sale, when Ray makes that final payment on his foreclosure on the same day of the sale, that's when the right of redemption is extinguished. So that means that after Ray buys the house, certificate of sale is issued, the defendant can come running to the courthouse again. Wait, I got all the money. I want to pay it off. It's too late. Now, can they get an attorney and try to fight the thing? Yeah, because, a lawyer can make an argument for anything. But is Ray going to win? It depends on what position he takes. Me, if I got certificate of sale and they want to pay it off, I'm taking the money. We'll figure out a way to make everybody happy. But essentially, the defendant's right of redemption is extinguished when the certificate of sale is issued. 10-day objection period. It used to be a 10-day redemption period. So the defendant had 10 days to redeem. Now it's when the certificate of sale has been issued. But the 10-day objection period, what that really is, and I don't know why we have it, but listen, there's guys a lot smarter than me that are making these decisions. So that you have to wait 10 days for after the sale for you to get CT. So the 10 days are known as the objection period. Anybody can file an objection. Anybody, and I know that guys that used to do this, Ivanhoe, that they would go to the sale, and if they wouldn't prevail, they would file an objection because the sun was in his eyes. He couldn't find a parking space. So whatever the objection is, the court will have to hear it. So that will delay CT from being issued. So I know some guys in Broward, if they don't get a property or a new guy wins the property and they're not in the group, they'll file an objection to sale, which will delay the CT. And it could take up to 20, 30, 45 days to get that thing done. And as you know, in this business, time is money. So the longer you have to wait for CT, the longer you have to wait to sell it, the longer you have to wait to rehab it, the longer it's a pain in the butt. But in most cases, thank God, nobody's going to file an objection unless there's a true objection. The certificate of title is issued by the clerk of the court on or about the 11th day. It'll make it to you around the 15th day. And now you have everything you need to sell the property. You can take occupancy. If there's someone in the house, I always suggest getting a writ of possession. You have to check your final judgment to make sure you don't have to have a hearing. If you have to have a hearing, go ahead and set it. Generally, you have to have an attorney to set a hearing in circuit court. But if you're in county court and it's an HOA foreclosure, I would roll the dice, take a shot myself. What the heck? All the judge can say is no, but it's going to cost you some time, because if he says no, you got to get a lawyer. Okay, I don't think there's anything left on this page. Okay, bye-bye. So there's my website. If you have any questions, you're obviously getting something from me to make you attend the webinar. But if you want to sign up for any, make sure I have your email so you can get all the stuff that I do.
I got a question about the defaulting. You're saying about the answer and defaulting.
Sure.
So when it comes to basically, I guess would be the defendant, if they have them 20 days, like that's not an issue for them, right? As far as that answer not being, like their answer will be looked at, right? You were saying that if it's not the homeowner, then those answers will be kind of put to the side or whatever, right?
No, all the answers, any answers that are filed will have to be weighed by the court, and they'll have to be pushed in front of the court by the plaintiff's attorney. So they'll push them in front of the judge, and it's a pretty simple argument, because any lien holder that comes after the mortgagee does not have rights that are more substantial or superior to the mortgage company. Gotcha. So that's all the plaintiff's attorney has to say is the second mortgage, even though What's funny about it is the second mortgage knows they're a second mortgage. They're recorded second. They probably even have second mortgage on the top of the damn thing. But their attorney with a straight face will go in and say, no, judge, our lien is superior to the first mortgage. No, you're not. But the attorney earns a fee, and that's the way it goes. So everybody goes in front of the judge, says they're superior. There's no proof, and the judge will go, no, denied, boom, defaulted out, or not defaulted out, but their answer has been considered, and we're going to overrule that, and we're not going to consider them to be a party or a problem, and we're just going to move forward with the foreclosure now. So everybody gets to be heard. Everybody gets their 5 minutes in front of the judge.
Gotcha. Okay, thanks.